So we're going to jump back into the final part, Richard Morgan Casey's testimony to the Post Office Horizon IT inquiry, and the draft Tomlin order that Sir Wynne asked him about before has now been found, kind of, but the load on the screen there is some technical difficulties. But however, when they're going through the agreement, it does appear to suggest that Lee Castleton can no longer speak negatively about Horizon, and that the Post Office will charge him $25,000 for the privilege if he does decide to do it, should he agree to the settlement before trial. And Richard Morgan, interestingly, describes the Post Office's proposed agreement as an unenforceable waste of space. Let's jump into the inquiry.
Any other questions?
No, there aren't, sir, except that we've now tracked down that document that I said I would come back to.
Yes, well, let's just have that up, please.
It's poll 308-1826.
So this was the draft Tomlin order, which referenced Clause 5, and Richard Morgan Casey couldn't answer the question on it before because he said that it wasn't possible to determine whether the paragraph below in the statement referenced Clause 5 in the Tomlin order or not, and Richard Morgan said he hadn't received a copy of it, only of the back page of it, so this is the document that they're now going to show to him and ask questions about.
Thank you, and if we go to page 17, please. No, that's the wrong document.
I'm beginning to wish I hadn't asked that question.
Me? Right. Just give us a couple of moments, sir. It was thought that the correct document had been uploaded whilst the last 45 minutes had occurred, and it seems that's not the case.
All right, well, the reality is that the document will, in due course, surface and be put on the screen at some suitable moment, and we'll all be able to see what, was it Clause 5 or Schedule 5 says?
Maybe, sir, if I can just read.
Yeah, that would be fine. That would be lovely. Thank you.
As what some people will call a workaround. The email was the 10th of November 2006, and at 1600 hours it enclosed the draft Tomlin order. It included the proposed text amended by Mr. Dilley and said, I attach a draft consent order for your approval. The real question is whether we need the undertaking in Clause 5 of the schedule. Richard thinks that by making a song and dance, we highlight a sensitivity, and the less we talk about it, the less likely it is that Castleton will seek to raise it. And then Clause, it's a 5-paragraph consent order, Tomlin order, to which there is a schedule. And paragraph 5 of the schedule says, the defendant undertakes to the claimant that he will neither repeat his allegations about the Horizon system nor make any further allegations about the Horizon system or its functioning, and in the event that the defendant breaches this undertaking, he shall both, 1, submit to an injunction restraining him from talking further about the Horizon system, and 2, pay to the claimant liquidated damages in the amount of £25,000, being a genuine pre-estimate of A, the claimant's costs of having to rebut such statements, and B, its loss of goodwill generally.
So let's just clarify this. We're already planning on bankrupting him through this illusory 25,000 plus Horizon shortfall and our insane legal costs we've used to pursue him for these illusory shortfalls. We now want him to agree to a settlement which says he'll never criticise Horizon, and that he'll also agree to give us another 25 grand, which is just an estimate, so presumably could go up. I mean, it could go down, but I'm suspecting it never would. If he does criticise Horizon, now the one thing that springs to mind is I do appreciate this kind of thing can be seen as fairly standard within settlement agreements. Whether it should be or not, I think is up for debate. However, if you are adopting the position that our system is extremely robust and infallible, then surely you don't mind if people are criticising it because you think, well, we'll win any case against them, hands down. They'll be seen as being a little bit batty, maybe, for criticising such a perfect system. It'd be like criticising a fact, you know. The sun rises tomorrow. Morning is morning. black is black, white is white. It'd be almost like disputing some kind of indisputable fact, unless, of course, you have some underlying concerns that you'd rather not be exposed, that actually the system that you are trying to defend is actually very buggy, very unstable, and very lacking in integrity, and you wouldn't like somebody who would be in a very good position to criticise said system to make their views known and continue to be known, particularly if you are also aware that other people are making broadly similar allegations in counterclaim against the Post Office for the allegations that they are raising for theft and false accounting. Just an idea.
So I think that the question is, the chairman asked you.
Yes.
You were asked, I think, for your view on that, and it's plain that although the wording that Mr. Dilley was proposing isn't exactly the same as in the draft Tomlin order, in particular because there are some consequential sub-paragraphs concerning injunctive relief and liquidated damages. You thought that, according to this record, that by making a song and dance, the Post Office highlighted a sensitivity. The less we talk about it, the better.
Yes. I would have also thought that the undertaking itself was unworkable and a complete waste of space, but I don't know whether I'd have expressed it that clearly.
And unenforceable.
And unenforceable. And an undertaking to a party rather than to the court. So, there we are.
For a range of reasons.
For a range of reasons, I would have been extremely adverse to it.
So from Richard Morgan's point of view, this isn't even legally going to fly, and I guess from the Post Office's point of view, what he's trying to say is the less you talk about Horizon, the better. Kind of indicates that maybe he's either sensed they've got worries, or the Post Office may have inadvertently mentioned, or maybe overtly mentioned, that they have concerns about Horizon potentially.
I think the question is, isn't this other evidence, however, of what the Post Office's real motivation was, i.e. to gag somebody from speaking, or alternatively, to require them to say something good about the Horizon system?
Regrettably, my experience of people trying to negotiate settlements is they ask for the moon when they've got no need for it. As I said, I was rather focused on trying to prepare for the trial. And this was just unnecessary noise in the background. I wasn't focusing on what the parties' terms necessarily were. With the benefit of hindsight, then I might have put more thought into what people's motivations were. But as I keep on saying, I was focused on a debt recovery claim.
There must have surely been at least a cursory interest in this, because should this settlement be agreed, presumably there wouldn't be a trial to prepare for at all.
Well, Mr. Morgan, you'll be glad to know that ultimately the motivation of the Post Office in respect of various of its actions is not for you or Mr. Beer, but it's for me.
So I haven't any further questions. Did you have any follow-up questions in relation to Clause 5 of the Tomlin order?
That's fine. Thank you very much.
I'm a terrible one for having one thought or two on the stairs. There was one thing I forgot to put. Could I put it quickly? It won't take more than a minute.
Well, I will hold you to 90 seconds, Mr. Henry.
I'm very grateful, sir.
Quickly.
Mr. Morgan, I'm so sorry. It just refers back to Mr. Dilley and what he said yesterday. He said at page 124 of the transcript that he asked you, and counsel advised us not to disclose the BDO Stoy-Hayward report. Because he quotes, he didn't think the Post Office needed it to prove its case. And then he said again at 136, I believe that I discussed this report with counsel. I cannot now recollect after the passage of time all the details of this discussion, but counsel was made aware of it and he advised not to disclose it. I'm sure that if he had considered that it should have been disclosed, he would have given me that steer. That's what Mr. Dilley says about that draft report. What do you have to say about that?
First of all, I don't remember ever seeing the draft BDO report. Secondly, I remember asking for accountants to prepare a report to summarise the ins and outs of all of the cash movements and stock movements, because that would have enabled me not to have to do it myself, and I was never provided with that. Thirdly, in civil litigation, you don't have to disclose any draft experts' reports, or indeed signed experts' reports, even if they're finalised. Until such time as they are exchanged, they are covered by privilege. Had he asked me, and I don't remember him asking me, I would have said, you don't need to disclose it. But in any event, I don't think I even saw it. I don't remember even seeing a draft BDO report.
I was going to ask then, how if he's not even seen the evidence, can he describe it as not disclosable? But then he seems to answer that there by saying, actually, just by the nature of it was a draft or it was a report from an expert, I didn't need to see it because I didn't need to disclose it if I didn't feel I needed it for the case anyway, is what I'm taking from that.
Again...
Well, that's a comprehensive answer. So I think that provides an answer to your question, Mr. Henry.
It does, sir. Thank you so much.
Can I also just say one thing? I have tremendous sympathy with what Mr. Castleton has gone through and his family. I can't say anything more than that, but I quite understand why he's upset by what's gone on. I hope that goes some way towards it.
Well, I guess that's very big of him. It's taken us a few hours to get there. He's sorry for what he's went through, but not for any part necessarily that he may or may not have played in it. Right.
Thank you very much for coming to give evidence, Mr. Morgan. We'll now adjourn until Tuesday. I think it's Tuesday, yes. And it's Mrs. Chambers, is it?
10 a.m. Tuesday and Chambers.
Yeah, fine. All right. Thank you all very much.
Thank you.